Well, we have another case that's going to be coming up soon, and I think this one's going to really gain some traction once it starts, especially considering it's dealing not only with mental illness and postpartum depression and suicidal tendencies. It's going to be a very emotional case, saying the least. It's a pretty involved situation. We're talking about the Lindsay Clancy case. The latest filings in the Lindsay Clancy case show a major escalation in the prosecution's strategy. Their anchor theory is now extreme atrocity and cruelty. They are elevating the charges to aggravated murder. This signals that the Commonwealth is no longer focused solely on intent or premeditation. They are preparing to argue that the killings meet one of the highest thresholds of brutality under the Massachusetts law. The filings also emphasize manual tightening of the exercise band, a detail that the prosecution is using to dismantle the defense's argument that Lindsay was in a disassociated state or an involuntary state. They argued that the physical act required repeating, tightening, controlled pressure, sequential awareness, and actions, they say, contradict the defense's claim of impaired consciousness on Lindsay's part. Another major development is the prosecution's push to admit Patrick Clancy's 911 call. They want the jury to hear the real time of the timeline, Patrick's emotional urgency, and his immediate observations as he discovered the children. The Commonwealth agrees that the call supports their timeline and reinforces their theory of deliberate action. Discovery is now nearly complete, signaling that both sides are shifting into full trial posture. The prosecution has listed approximately 168 witnesses, while the defense has approximately 50. The size of this reveals the depth of the Commonwealth's case and the more targeted approach of the defense. The filings also show the prosecution preparing to argue that Lindsay's actions were intentional, sequential, and goal-directed despite any mental illness. Their position is very clear. They have indicated she is undoubtedly mentally ill, but she is not insane. The June 18th hearing served as a procedural check. The court reviewed the new filings, confirmed the status of remaining discovery, and kept the case on track to start on July 20th. No major rulings were issued, and the prosecution is expected to continue pushing for the admission of the 911 call in upcoming motion hearings. The filings paint a picture of a case tightening around its final pretrial phase. Patrick's 911 call, raw, immediate, and devastating, it is central to the prosecution's emotional strategy. They want the jury to feel the urgency of the moment and understand that the timeline was unfolding through that 911 call. The defense continues to emphasize Lindsay's mental health crisis, postpartum collapse. But the prosecution's filings show a clear effort to narrow the emotional space available to the defense. They are drawing a line between mental illness and legal insanity, preparing to argue that Lindsay's actions fall on the wrong side of that line. As the case moves toward trial, the emotional weight grows heavier for the families, for the community, and for everyone following this case. A reflection on the context. The prosecution's extreme atrocity and cruelty theory that elevates the charges to aggravated murder requires proving conscious awareness and excessive brutality, signals confidence in proving intent and deliberate action, undercuts the defense's impaired state argument. The manual tightening of the exercise bands. The prosecutors will emphasize repeated tightening, controlled pressure, sequential actions. This involves physical awareness. Why this will matter? It directly attacks the defense's foundation that Lindsay was incapable of forming intent. Patrick's 911 call. The prosecution wants the jury to hear the exact timeline. Patrick's discovery of each child, his immediate observations, the urgency and the emotion of the phone call, and why it supports their timeline and emotional framing. The discovery is nearly complete. This means evidence exchange is almost finished. No major surprises remain. The case is shifting into trial posture. Motions now focus on admissibility. The witness list has been secured. 168 witnesses for the prosecution and 50 for the defense. The Commonwealth is preparing a broad, detailed case. The defense is preparing a narrow, more focused rebuttal. The prosecution's filing theme. They are preparing to argue. Lindsay planned the sequence. She acted with complete awareness. She understood what the consequences of her actions would be. She took steps before and after. Her mental illness was real, but it was not incapacitating. June 18th hearing. And what happened? The judge addressed the issues that were filed on June 11th and 12th. He reviewed new prosecution filings. He heard preliminary discussions. No major rulings were issued. Remaining discovery check. The key questions addressed. What remains outstanding? When will it be delivered? Is anything in dispute? July 20th trial date has been confirmed. Judge confirmed both sides remain on schedule. Expert reports are on track. Witness lists have been filed. No delays are anticipated. The 911 call issue. Prosecution renewed this once again. The prosecution is pushing it, and they're pushing it very hard. The judge will address admissibility in a later motion hearing. This case is now entering into its final pretrial phase. Both sides are preparing for the July trial that will hinge on intent, awareness, and the line between mental illness and legal responsibility. It is a heartbreaking case. I don't know at this time if there's been any ruling on if it will be televised or not, but any further updates I get, I will let you know as soon as possible. Thank you, everybody.